I'm Claudio Simpkins, attorney at law, and this is Better Call Claude. Today we're going to be talking about landlord-tenant law. Now I want to start off by saying this. If you end up in a situation where you've got questions about landlord-tenant law or you need a housing lawyer, you should definitely consult one, somebody who's an expert in the area. Because this, even though we're going to go over the general field of law and I'm going to give you guys some tips about how to protect yourselves, doesn't constitute legal advice. And it definitely doesn't mean that I'm your lawyer. So again, if you've got a question about it beyond this, talk to a real housing attorney. Now, landlord-tenant law. Today we're going to talk about what your rights are and where you're protected, mostly as a tenant in New York City. If we're talking about landlord-tenant law, it's because you're moving into an apartment. You've either got a lease or you don't have a lease. Either way, you're fine, but if you have a written lease, obviously you've got a couple more protections than those who don't. If you have a written lease, for example, a landlord can only kick you out with good reason. If you don't have a lease, you're what we call a month-to-month tenant. And in those situations, a landlord can kick you out without good reason. They've just got to give you 30 days notice and they've got to take you to court. But the first thing I really want to talk about is the security deposit. Now we know this is where a lot of people lose a lot of money. There's usually a lot of funny business involved in security deposits. But I want to break down exactly what's supposed to happen with a security deposit, what you're entitled to, and what the landlord's obligations are. Security deposits are supposed to be treated specially. In other words, they're not supposed to be just mixed and mingled with the landlord's regular funds. And in situations where your landlord has a big building, let's say 6 apartments or more, your landlord's supposed to put your security deposit into an interest-bearing account in a New York bank. They're supposed to give you a heads up about what bank that is, where it's located, what the account is, that kind of information. The reason why is because you're entitled to the interest. Let's say you stay in an apartment for longer than a year. Maybe you've got a 2-year lease and you're coming towards the end of year 1. Your landlord is supposed to notify you about how much interest you've made. And then you've got a choice. Do you want to take that interest and you want to apply it to this month's rent? Do you want to just say, give me a check for that, like $7.50? Or do you want to just hold off and wait until the end of your tenancy and then take all the interest that your security deposit has made and apply that to whatever your last month's rent might be? Now, of course, what we really talk about or want to talk about when we're talking about a security deposit is what happens at the end of your tenancy. What can a landlord really hold or take some of your security deposit for? And that's a good question. If we want to be real about it, landlords take security deposits for any kind of old thing. Oh, you painted the walls in the bathroom pink. I don't really rock with that color. And in order to rent this space out to somebody else, I've got to paint those walls back white. I'm gonna now take some of your security deposit for that. Technically, that's not what a security deposit is for. So what's a security deposit really for? Under the law, the security deposit is only supposed to be used for repairs that go beyond normal wear and tear. Now, obviously, if you're living in a space for 6 months, a year, 2 years, or even longer, things are gonna get messed up, right? Walls will get painted or get dirty. There'll be dust and dirt here and there. Maybe a handle came off of a cabinet. Maybe the bathtub, when you try to put on the hot water, it's a little squeaky. That kind of stuff happens. That's normal wear and tear. What the security deposit is there for is to protect the landlord against repairs that have to be made when you leave that go beyond that. Now, obviously, if you and your partner got into a fight and somebody kicked a hole in the door, that should be coming out of your security deposit. But otherwise, you're entitled to get that money back. What's important to know is that the landlord is obligated to give you that money back, whether you request it or not. So there should be none of this funny business about, I don't know where my tenant went. I didn't have the address. They didn't really come for me for the money. No. Under the law, that security deposit is supposed to be given back to you, and the landlord should generally tell you exactly what they took out of your security deposit and what for. They should have receipts. And if they're gonna have receipts, you wanna have them too. But pro tip, whenever you leave your apartment at the end of a lease, make sure that you clean it up as well as you can, obviously, but take photos and video of everything. Because that way you've got the receipt should you ever have to go to court and show a judge that your landlord took some of your security deposit for different things that didn't constitute beyond normal wear and tear. That you left the condition of the apartment as top-notch as you could, and that there's no reason why the landlord should be pocketing some of your security deposit. Next up, we want to talk about a really big topic. You've already moved into the place, you paid your security deposit. Now, who can you live with? And what's your living situation going to be like? I'm talking about subletting, I'm talking about roommates, I'm talking about sharing space. Subletting is the first big topic. A lot of people wonder if they're entitled to sublet. Now, what do I mean by sublet? Sublet is you're going to be moving out of a spot for a month or two. Let's say you got a little bit of dough and you're going to backpack around Europe or South America. And you want to be able to have your buddy come in and stay in your apartment for those 2 months and pay the rent in your stead, or maybe pay you so you can pay the rent. That way you're not on the hook for the rent while you're not getting to utilize the apartment. Must the landlord allow you to sublet your space if you're going to be leaving? No, not really. So in New York City, there is no implied right where you're guaranteed to be able to sublet your apartment. You're gonna have to get consent from your landlord. So the pro tip here is everything in writing. Obviously, as a lawyer, I'm always gonna say put everything in writing, right? So what you wanna do is you wanna send a notice to your landlord. You wanna put it in certified mail, return receipt. And you wanna say, hey, listen, I would like to sublet my apartment. Here's why. I'm going to China for a month or two. And I want Joe Schmo to move into my spot. They're gonna be here from these dates to these dates. Do I have your permission to sublet? If you've given written notice like that, the landlord's got to respond. If a landlord doesn't respond in a reasonable amount of time, then essentially the law says you can go ahead and sublet. And if a landlord decides that they don't wanna allow you to sublet, they've gotta give a good reason. If they don't give a good reason, say, I don't like black people, or that person looks a little smelly, then you can take them to court and you can basically get it enforced that you're able to sublet, and there might even be other penalties for the landlord. So there's gotta be a good reason if they're gonna deny you the right to sublet, but if they've got a good reason, they don't have to let you sublet. Now, roommates. Who can you have in your apartment? Let's assume that you got a lease and you're the only name on the lease, but you got a couple extra bedrooms, you got some nice space. You wanna bring some folks in to live with you. Who's naturally entitled to come and live with you? It's generally who you would expect. Immediate family is okay. Kids, dependents, anybody that you're responsible for is okay. And essentially, if you want to have a boyfriend, girlfriend, spouse, anybody like that, you can have one other co-tenant. But the landlord's always going to have a little bit of leeway when it comes to overcrowding. So if you've got a tiny little spot, you obviously can't have like 17 of the homies flopping and crashing with you. That's going to be problematic. Now, here's a really hot topic that a lot of people are like wondering about, but it's been shady and people don't necessarily know how it's working. If you see an apartment on Craigslist and it's got 4 bedrooms and you want to move into it because it's an amazing space, it's got a rooftop, you got a backyard, all the new appliances, all that jazz. But the landlord says, I want you to sign an individual lease for your bedroom, and then I'm going to pick the other 3 roommates and they're also going to have individual leases with me. That's illegal. And a lot of people don't know this. So again, it's illegal for a landlord to take an apartment, a shared space, and start having individual leases with each person in that apartment. A landlord can always say, all right, Joe Schmo, you're able to have this 4 bedroom and you can bring in whatever 3 roommates you want, but you and I are the ones who have the lease together. It's illegal for that landlord to say, I'm gonna have a lease with John, I'm gonna have a lease with Susie, and I should probably have more ethnic names, but you know, other folks can have other leases. It doesn't work that way. It's a complicated thing that has to do with single room occupancies and hotel laws, but all you need to know is that landlords only do this because they feel like they can get away with it, right? It's a way for them to make a little bit of extra cash. They can probably charge each individual in a 4-bedroom $1,000 a pop and make $4,000 instead of charging one person who would be on the lease for that 4-bedroom $3,500. Or they just assume that as a tenant, you're dumb and you don't know where your rights are. But if you talk to me, you're gonna watch this video, you're gonna understand that that's illegal, so don't fall for that trap. And finally, I wanna talk a little bit about repairs and what happens when your lease is up and it's time to get out. Now, all leases are built in with this one provision called an implied warranty of habitability. It's a fancy legal term for basically saying the landlord has gotta make sure that the space that they rent out to you is habitable, that you can live in it. And it doesn't mean that your space has to be like the Plaza. It ain't got to be like the penthouse in Williamsburg, Water's Edge, whatever those new apartments are, right? It just means that you've got to have heat in the wintertime, you've got to have hot water, and your space should be free from any kind of infestation of cucarachas or rats or mice. But the landlord is also entitled to maintain the common areas, such as the stairs and outside the front of the apartment, a backyard if you've got that, hallways, any kind of common areas like that. And you're entitled to ask for repairs, and those repairs have to be made in a timely fashion. Now, what timely means depends on the severity of the condition. So obviously, if your roof caves in, the landlord needs to get on that pronto. If there's just, for example, the handlebar again on your cabinet is off, you're not necessarily entitled to run to the courthouse after a couple of days if that hasn't been repaired. Now, let's say it's time to go and a landlord wants you out of the apartment. Now, this is something a lot of folks have to deal with, either because landlords nowadays want to renovate their apartment buildings and then flip them, or they want to renovate them and jack up the rent for somebody else to come in. What can a landlord do to get you out, and what are your rights and your protections as a tenant? Again, like I said, if you don't have a lease, all the landlord has to do is give you 30 days notice and take you to court. They don't even have to have a reason to get you out. But if you have a lease and it's the middle of your lease, then the landlord needs a good reason to get you out, because the lease is essentially a contract between you and the landlord that says that you have the right to inhabit or the right to possession of that apartment for however long the duration of the contract is. So what are some of the reasons why you might be kicked out? Well, it has to be a substantial violation of something in the lease. Let's assume you've got a written lease, right? So if your lease says no smoking and no pets, and you've been sitting in there chiefing marijuana with your dog for the last 3 months, your landlord's probably entitled to get you out. But if the landlord just decides that on a Tuesday they're not rocking with you and they want you out for whatever reason, that's probably not going to cut it when it comes down to court. And court is important because at the end of the day, the only way for a landlord to get you out of an apartment in New York City is to get what's called a judgment of possession. They need a judge to say that they are entitled to take possession of that apartment back from you. So that means that they're going to have to take you to court. If a landlord wants to evict you, they generally have to give you notice. And then after that notice is passed, and if you're still in the unit, they have to file an action in housing court. There's two kinds of actions, right? First action is called a non-payment proceeding. Obviously, this kicks in if you have been non-paying your rent for the last however long it may be. In that situation, you're violating a substantial term of the lease, which is that you gonna pay money for your space. And a landlord is entitled to take you to court and get you evicted and get the money back. The other situation, why a landlord might take you to court, is called a holdover proceeding. And it's also what it sounds like. Let's say your lease has ended and you're still there and they've given you 30 days notice that they want you out, and you've decided I'm gonna hold up over in this apartment until you kick me out, then they can go to court and institute a holdover proceeding and try and get a judgment of possession. Either way, they're going to have to serve you with legal papers. And those legal papers will say you need to come to housing court in Kings County or Queens County or Manhattan or wherever. And that's where you're going to want to talk to a lawyer, because there are different ways you can fight it and you have different rights. But essentially that process all boils down to whether or not the landlord can get that judgment of possession. And even when they get the judgment of possession, that still doesn't mean you have to be out just at that moment. Because the only way a landlord can get you out is with the marshals. After getting a judgment of possession, a landlord has to get a warrant to evict you. And the people who can enforce that warrant are the marshals. So a landlord can't do it on their own. This is what we call self-help in the legal business, right? This is when you hear those horror stories about landlords who will harass somebody to get them out, or they'll lock you out of your apartment, or they'll take all your stuff and they'll put it into a hallway, or they'll put it outside. That all constitutes self-help, and it's illegal. So if your landlord's engaging in any of those practices, you're actually in a good spot, even though it's tough in the individual moment. Because if a landlord engages in self-help to try and get you out of an apartment, you could be entitled to what they call triple damages. Whatever the cost of the rent is, or fixing your stuff, or getting back into your place, or renting a new place to hold you down until you're able to get to court. You might be able to get 3 times as much money, because the state and the laws want to punish and discourage landlords from engaging in self-help, right? There's an established process to evict somebody. They've got to go to court, they got to get that judgment of possession, and then they got to go get their warrant, and they got to take it to the marshal, and then the marshal got to... It's an established process, and the courts want to encourage landlords to engage in that process. So if you go into self-help means and a landlord decides that they're going to harass you or lock you out or find some other way to get you out of the apartment, they're basically in trouble. They could face civil fines, criminal penalties, or those treble damages if you take them to court. So essentially, as a tenant in New York City, you've got a couple of different ways to protect your rights. There's a couple of different things to be aware of. You should always be wary of how your security deposit is being treated. You should know your rights as to who you're entitled to live with and whether or not an apartment can be shared with multiple people on individual leases. And you should basically understand how eviction works so that you're not going to be bullied or you're not going to be pushed out or you're not going to be harassed out of your place, but you also know that you need to respond when you start to get notices to evict and to show up in court. Again, if any of this stuff is important to you and is timely to you and you're in a situation where you need further advice, I definitely recommend you go talk to a housing lawyer. But for now, this has been Better Call Claude. This is an overview of housing law in New York City, and we thank you for watching.